Good afternoon, everyone. My name is Teilen Celentano, and welcome to today's iteration of the Live Employment Law Q&A by employmentlawyer.ca. I'm an associate with Samfiru, Tumarkin, LLP, and I work out of our Toronto office. So, as always, today, please feel free to ask your questions, whether live through YouTube, Facebook, LinkedIn, X, what have you, and I'll do my best to answer them live. You can also go to our website, employmentlawyer.ca, email us at help@employmentlawyer.ca, or call us at 1-855-821-5900. So I'd like to start off today by talking about everyone's favorite topic, the Toronto Maple Leafs, and specifically how they just let go Sheldon Keefe. So their head coach, Sheldon Keefe, his termination raises a lot of issues that we here at Samfiru Tumarkin see on a daily basis. So from the start, Sheldon Keefe, like every other coach in the NHL, is part of a union. So the coaches in the NHL are unionized, and therefore there's a specific grievance process that is prescribed by that union. So technically speaking, he would be unionized and would fall under the umbrella of labor law rather than employment law. That said, we can still use his case and his circumstances to talk about the other issues. So the first of which is performance, right? It's obvious that Sheldon Keefe was let go because he didn't meet the performance expectations of management, ownership, and of the fans, right? But the question becomes, is that enough? Was that poor performance enough to terminate someone for cause and not pay them any severance? The short answer is no. In Ontario, termination for cause is viewed as the capital punishment of employment law, meaning it is only appropriate for the most heinous types of misconduct. Just like capital punishment in criminal law, it doesn't even exist here, but in the US is reserved for the most heinous of crimes. So for the Leafs in this case, they still made the playoffs. They were still a good team. They still had the league's leading goal scorer. There's absolutely no way that the Leafs would be able to establish that they had just cause to terminate Sheldon Keefe's employment on the basis of performance. Instead, if he was let go, he was a regular Ontario employee who was non-unionized and he was let go, then he would be entitled to a full severance package. What that full severance package is depends, again, on a number of factors. So our courts look at any number of things to try to ascertain how much severance, how much pay in lieu of notice of termination one person is entitled to. The biggest things they look at are age, length of employment, and availability of similar employment. It's that third one, availability of similar employment, that really would be applicable to Sheldon Keefe and him trying to find a new job. In his case, there are 32 NHL head coaching jobs. And in every season, there may be 3 to 6 of them that are vacant, 20%, but there still isn't a ton of jobs available, right? And when jobs are more scarce, like being an NHL head coach, it is generally the case that the employee gets more severance. Another thing that's important here is compensation. Our courts have recognized that jobs that pay multiple millions of dollars a year, like Sheldon Keefe was earning, are much harder to come by than your entry-level position, than your minimum wage position. And therefore, people who make millions of dollars who will have a harder time finding that same job get additional severance. And then the last thing, right, to consider here is whether he was an indefinite or a fixed term employee. Most coaches in the NHL, I think all, but I may be mistaken, are signed to what's called fixed term contracts. So they're not signed to be the Toronto Maple Leafs head coach indefinitely. They're instead signed a contract that's 2, 3, 4, 5 years. It says you will be the coach from today and then the next 5 years. In Ontario, when an employee is terminated early, right? So if they're terminated prior to the end of that fixed term contract, they're generally entitled to be paid the balance of that contract. So if you are terminated after 2 years, and you signed a 5-year contract, then your severance entitlement in that case would be the last 3 years. They would have to pay it out as if you had continued working. So there are a number of things that we see every day that all come up with respect to Sheldon Keefe's employment. And it is, I think it was probably time that the team move on, but it's a very interesting case. So I'm going to jump into a few questions. We've got a question on YouTube from Sammy. Can an employer choose to stop paying medical benefits? I've had coverage for 4 years and my employer is talking about ending them. So Sammy, what your employers can't do that. And it can, depending on the circumstances, result in a constructive dismissal. So what a constructive dismissal at its most basic form, right? What our courts say, the one sentence description, is a substantial unilateral change to the terms of employment. And when that happens, an employee can choose to either accept that change, or they can treat their employment as having been constructively dismissed and pursue severance. In your case, there are many times where cutting benefits can result in a constructive dismissal. Now, just because it has happened doesn't mean it happens in every case. So, Sammy, it's important that you reach out to us at employmentlawyer.ca and speak with one of our lawyers who can really look at your case individually. One of the realities is constructive dismissals are a very fact-specific analysis, meaning although there may be similarities between different cases, it's really important that someone, a lawyer, looks at your file, looks at your case, looks at the circumstances of your employment, really does their best to ascertain whether it's a constructive dismissal in this case. So can they do it? I mean, employers will continue to do it, but that doesn't mean you're without rights. And your right in this case would likely be pursuing a constructive dismissal claim where you'd be entitled to a full severance package as if you had been just regularly terminated, right? So our courts, when they do these analyses, they look at, was there constructive dismissal, yes or no? And if the answer to that question is yes, then for the rest of the case, for the rest of the analysis, it's treated as a regular termination, as if a boss had just walked in and said, here's your record of employment, you're being let go today. So Sammy, definitely reach out to us. One of our lawyers will be able to help you out. The next question, again on YouTube from Linda. When being asked about your employer to move to a new work location, how far is too far? If you don't drive and rely on transit, does that factor into it? So again, another constructive dismissal issue. Constructive dismissal cases can take a million different forms. How far is too far, again, is a case-by-case analysis. Depends on where you live, depends on what kind of job you do. And in your case, it depends on whether or not you drive. In the past, our courts have said that in the GTA, Greater Toronto Area, driving upwards of an hour is to be expected. So if your drive is being changed from 20 to 40 minutes, that might not be enough. But in other places in the province, that doubling the drive from 20 to 40 minutes might be enough. It is really and truly a case-by-case analysis. And also, is it kilometers or time? What time are you traveling, right? Are you someone who works 9 to 5 and you're moving from the outskirts 10 minutes from your house, the outer outskirts of the GTA, office is moving downtown, you have to be there at 9, so now you have to fight traffic on the Gardner or on the DVP the whole way in and the whole way out. And if that's the case, even though your drive might only be increasing by 5 or 10 kilometers, it might add 90 minutes to your travel each way. Similarly, if it might be a short drive, right? They may be adding 40 kilometers onto your drive, but if it's only adding 30 minutes, it's a different analysis. So everything would come into play. When do you start? When do you end? What are the expectations in terms of attendance? There is no rule of thumb. There's no basis. There's no bright line where I can say how far is too far. I can't say 30 kilometers is too far. I can't say 30 minutes is too far. I wish I could, but unfortunately I can't. So instead, you would have to, again, speak with one of our lawyers to be able to look at your case individually and try to ascertain, whether or not the drive that you're being asked to do would be enough to, trigger a constructive dismissal and allow you to pursue a severance package. Lee on YouTube asks, can a consultant in the government be considered an employee even if they have a consultant for professional services for 5 to 6 years? My contract wasn't renewed last month, but no severance. I'm non-unionized and no longer have a job. So Lee, yes, you can still be considered an employee, and it's important that you reach out to us right away before you do anything else. So a consultant is another term for an independent contractor, and their independent contractors are not considered employees. They're a distinct class of worker, and they're treated differently. So generally speaking, independent contractors are supposed to be in business for themselves. They're supposed to operate a business and be contracted out. But our courts recognize that employers, governments included, will oftentimes treat people as consultants, as contractors, when in fact they're employees. And in order to determine whether that worker was an employee or a contractor, then our courts will look at it and say, okay, there are four big things that they look at. It's control, and that's the biggest one. How much control does the employer exercise over the employee? Do they set a dress code? Do they have a uniform? Do they tell you what to wear? Do they assign you work? Do they tell you how to do the work? Do they tell you when you have to be there? Are there confidentiality provisions? Are there exclusivity provisions? These are all things our courts will look at to take a look at control. And if the more control there is, the more likely that you're an employee. The second thing they look at is ownership of tools. Do you own the tools required to do your job? So if you think of the quintessential example, the one I always use to talk about this is a plumber, right? Obviously, we're a law firm. We have toilets in our office, and we need plumbers to come in and fix them. But they come in, we say, we need this toilet fixed. They fix it. We don't tell them how to do their job. We don't tell them when they have to show up. They come and they do their job as plumbers, and we're hiring them for their expertise in that field. If you're going to work every day and they're giving you your laptop, whereas the plumber is bringing in his own tools every day, again, that if the company owns the tools, if the government owns the tools, in your case, it would lead to the conclusion that you're an employee. Other thing they look at is a chance of profit or risk of loss, right? So if the employee has a chance to make a profit or risk a loss, then there's a conclusion that they're more likely to be a contractor in business for themselves. An example might be you're hired to do this one specific project. Rather than getting paid an hourly rate, there's a flat fee, right? To fix your toilet, it's $1,000. Well, if that plumber can get it done in an hour, they can then go to another site, take on another job. There's this chance where they can make a huge profit. Similarly, if they quote a price and it takes them much longer than expected, well, now all of a sudden there's a risk of loss. But in most cases that we see, these professional service consultants, these independent contractors, they're paid either a base salary, an hourly rate, and they are just expected to work for those hours, right? Submit your hours, show up every day, and we'll give you this paycheck. There's no variability. There may be variability in a week because I work a couple extra hours, so maybe I make a little bit of overtime, but that's not a chance of profit or risk of loss. It's really whether or not you have that ability to do something more than just an hourly rate, base salary, overtime, etc. And the last thing they look at is the organizational test. So how core are you to the organization, and what is your how core are you to that organization, and do you hold yourself out to be part of the organization, right? So did you have an ontario.ca or a .gc.ca email? If so, you're holding yourself out to be an employee of them, right? You're representing to people outside of the organization that you're an employee. Other things as well, how essential is what you do to the operation, right? Are you the plumber who comes in and fixes the toilets at a law firm, which is obviously important, but it's not something it's not a service we market, not something that is core to our business? Or are you a lawyer at a law firm where what you do is at the very core of what the business does? And then once all that is considered, our courts look at everything, and then they make a determination. Is that person an employee or a contractor? More often than not, when we see these cases, those people are employees. And in addition to being entitled to severance, there's also a number of other things that employee might be entitled to that they've been deprived of, in your case, for 5 to 6 years. Public holiday pay, vacation pay are two things, are money that's essentially being taken out of your pocket because they have misclassified you. Now, depending on whether you're a provincially regulated employee and a federally one, how much vacation pay you're entitled to depends. But the bare minimum under both legislations, the Employment Standards Act and the Canada Labour Code, is 4%. So the bare minimum, if you've been misclassified as a consultant or as a contractor, you haven't been provided with your 4% vacation pay. Additionally, there's public holiday pay. If you're a contractor, you probably haven't been receiving your public holiday pay, which on the year is equal to anywhere from 3.5 to 3.8%, depending on the year, depending on the person's employment. So not only are you being deprived of severance, you're being deprived of additional monies throughout your 5-6 years. And the last thing I want to mention while I'm on this topic, Lee, is that even if you are a contractor or consultant, you can also be this middle class, which is called a dependent contractor. So in Ontario, our courts have said there are cases where a contractor is truly a contractor and not an employee, but they're so reliant on the company that not renewing a contract or not or terminating the relationship will cause that person significant harm. So what our courts have said is those people, those consultants, are dependent contractors, and because they're dependent, they're entitled to severance as if they were an employee. So Lee, there's a lot of stuff, and again, the cases like yours need to be reviewed on a specific individualized level, but there is a real possibility that you've been misclassified for the past half decade. And if that's the case, then not only might you be entitled to severance, you could also be entitled to back holiday pay, back vacation pay. So give us a call and one of our legal reps will be able to help you out. Robbie from Facebook asks, can an employer fire you for having an alcohol or drug issue? I just started a rehab program on my doctor's orders. So Robbie, I'll start from the point that under the Ontario Human Rights Code, all disabilities are protected, right? So an employer is not allowed to discriminate you on the basis of a disability, right? So whether that disability is physical, a broken leg, or it's mental health, depression, anxiety, or it's addiction. Addiction, alcoholism is a medical disease, is diagnosed by doctors, is treated by doctors. It is therefore a disability under the Human Rights Code and under the Canadian Human Rights Act. If you are being ordered to attend rehab by your doctor and you're doing that, then no, your employer can't terminate you because of it. Now, that's not a green card to, drink alcohol or take drugs at work. That's not what that is. But what it means is the employer has to accommodate you. They have to let you have that time off. They have to do everything they can to allow you to work with your disability, which in your case is addiction. So no, they can't terminate you for having a drug issue. Now, the caveat there is if you're drinking and doing drugs at work, that could sometimes be cause, but even then, if an employer knows you have a disability, they have enhanced obligations to accommodate your disease, your disability. Dwayne Jackson on YouTube asks, can an employer give you an involuntary termination when you're on disability from a doctor? Also had a count on upper management stealing freight contractor were caught by security. So I'll start with the first one. Can an employer give you an involuntary termination when you're on disability from a doctor? So while you're on disability leave, can your employer terminate you? So generally speaking, no, right? So under the Employment Standards Act for most employees in Ontario is applicable legislation. You're not only entitled to have a medical leave, right? An unpaid medical leave as long as you need it, but you're also entitled to be reinstated to the same position if it exists or to a comparable one if it doesn't. So can the doctor terminate you? No. Or can your employer terminate you while you're on a disability leave? No. But there's another topic there, which is a little more nuanced and it's a highly legal technical argument. But what it is if you've been off for so long and that there's no reasonable prospect of you ever returning, then there's a chance that your employment has been what's called frustrated. Frustration, that legal principle exists in every area of law. It's not unique to employment law. And what it means at its most bare bones level is that a contract can no longer be performed through the fault of either party. So it's not your fault you're on a medical leave. It's not the company's fault you're on a medical leave. It happened. And because of that medical leave and your now medical condition, you can't work. There's no reasonable foreseeable time in the future when you will be able to work. And if that's the case, and the employer follows all the rules that they have to, and there are a lot, then they can trigger frustration. And in that case, when an employee in Ontario's employment has been frustrated due to a disability, then they are entitled to their minimum entitlements under the Employment Standards Act. So I think the short answer is, can they terminate you? No. They may be able to trigger frustration, Dwayne, but if your employer is doing that, either terminating you or trying to trigger frustration, there are a lot of times where employers will not do it correctly, and then that employee is entitled to a full severance package. So reach out to us. One of our lawyers will be able to take a look at your file and hopefully help you out, Dwayne. I'm not sure what you meant about your upper management stealing freight. Now, if you want to rephrase that question, maybe help me out. I'm happy to revisit it. We've got a question on Facebook from Veronica. My employer is telling employees that they must download an app on their phone to upload photos of jobs to the company database. The system is requesting access to my personal photo album. Is this allowed? I don't feel comfortable using my personal device for work. So it depends, Veronica, on what the terms of the employment were when you started. So this sounds like a new thing, and it sounds like you've been working there for a while. So I would say likely you're allowed to say no. But if it was a term of your employment, right? If it was a term of your employment when you started, meaning I'm starting, and in the contract it says you will need to use your personal phone to upload photos, et cetera, and you agreed to it and you filed it and you signed it, excuse me, then yes, they're allowed to ask you to do it. That said, if it's a new request, right, which it sounds like it is, and they're saying we need you to download this app to do your job, and it's your own personal phone, you're allowed to say no, right? You don't have to say yes. You can say, I'd happily do it if I had a company phone, this, that, the third. You don't have to say yes. But one of the difficult things, and it's one of the things I always run into in my work, is that employers in Ontario always retain the right to terminate somebody's employment for a non-discriminatory reason, right? So provided there's no issues of discrimination or other issues, generally speaking, employers can let someone go without cause. And what makes that dismissal a wrongful dismissal is they have to pay severance. They have to pay the right amount of severance. So if you said no, Veronica, and your employer wasn't happy with that, they could still let you go. But if they chose to do that, you'd be entitled to a full severance package. So without knowing the specifics of what your employment looked like beforehand, I can't say for sure, but I think it's likely by the sounds of things that you can say no, and they won't. You can say no to this request if you feel uncomfortable. Stacy on YouTube asks, if you filed a harassment, bullying, discrimination complaint against the CEO, the results have only been forwarded from a third-party investigator almost 2 weeks ago, but I haven't heard any outcome from the investigation. I'm concerned they are putting together a buyout package. Are they legally allowed to release that to me under the circumstances? So Stacey, I'm not quite sure what you mean. I know you said you filed it at the end of last year. There's a lot of fact-specific circumstances here. You're entitled to know what the outcome of the investigation is, right? What the actions being taken against the person you filed the complaint against are. But the work product itself, you're not necessarily entitled to. It could be protected by privilege. If it was, if it was a lawyer who did the investigation, it could be protected by attorney-client privilege. It could be protected by litigation privilege. You may not be entitled to the full investigation notes, but you are entitled to know what they're doing, right? So if you filed this, how are they going to protect you going forward? What are they going to do to make sure you're protected in the workplace, because they have an obligation as your employer to provide you with a safe workplace. Now, with respect to the buyout package, I'm not sure if you mean a buyout package for yourself or a buyout package for the CEO, right? So if they want to let you go, again, it would depend on why they're letting you go. Right. So if they're letting you go because you filed this complaint and they just don't want to deal with you anymore, that likely is discrimination. Right. It's discrimination on the basis of gender, sex. And it's also a reprisal contrary to OSHA. OSHA is the Occupational Health and Safety Act. So if you file a complaint, OSHA protects you. And if they terminate you because of that complaint, then that's a violation. And with OSHA, we can actually apply for reinstatement or seek reinstatement, excuse me. So, I think for right now, if you're worried about it, if you're afraid they're going to buy you out, if they're afraid you're going to let go, then reach out to us at employmentlawyer.ca, speak with one of our lawyers, and they'll be able to help you out and advise whether or not you're protected, what your specific protections are, and what can happen if they do try to buy you out. A question from Jackie on YouTube. I worked for 4 years as a cleaner. My contract expired in March. I was told I would be moved to a new job site, but now they are saying that they don't have a new site for me to work. Is there anything I can do? So, Jackie, it depends, right? Were you employed on a contract that was a fixed term contract that just expired? Were you an indefinite term employee, meaning you maybe never signed a contract, or you signed a contract that said you'd work until you wouldn't, but there was no set end date? And if that's the case, you're an indefinite term employee. They said, we're going to transition you, stop giving you work, and then they have nothing for you. Excuse me. Well, then in that case, it's likely that you've been terminated and that you're entitled to severance. Now, if you've been employed pursuant to a series of fixed terms, well, then it's a different analysis. And in that case, well, maybe you might not be entitled to anything. Like always in law, it's a very fact-specific, case-by-case analysis. So it's important that you reach out to us at employmentlawyer.ca and speak with one of our professionals. Okay, so last question for today, and then I want to talk about one other thing, and then we'll wrap up. So Cristiano on YouTube asks, I'm unionized. Can you help me get my severance pay? Short answer is no. So when you're unionized, your employment is governed by a collectively bargained agreement, right? So that agreement is bargained between your union head and the business. So because of that, because you're in a union, your path to severance adjudication must be done through the union. So if you've been let go, if you think you've been constructively dismissed, you need to talk to your union rep and follow the appropriate protocol. As a lawyer, I can't get involved in union issues. Myself, I'm an employment lawyer. I'm not a labor lawyer. The difference is employment is non-union, labor is union. So definitely go through your union. Hopefully they'll be able to help you out and get you the severance you're entitled to. The last thing I want to talk about before I sign off today is just the recent layoffs in the tech industry. So it was recently announced that Microsoft and their subsidiary Xbox has decided to close multiple game studios, and a ton of Canadians are being laid off as a part of it. So mass layoffs are something that we frequently see in economic times like these, when things aren't booming. And in that case, when you're being laid off as a part of a big group, some people think that whatever they're being offered is fair, and that's not necessarily true. Your employer is likely still going to offer you a package, but just because they offer you something doesn't mean that it's enough. Frequently, employers, especially in mass layoff situations, will make packages that are less than fair in hopes that the employees just take the deal and it's over. So in all situations when you're let go, and especially in mass layoff situations, it's important that you give us a call, reach out to us at employmentlawyer.ca so that one of our lawyers can take a look at everything and let you know whether the offer on the table is fair. But thank you all for joining me today and for your questions. That's all the time I have. Feel free to join us next Monday with my colleague Luke, Monday, May 13th at 1:30 p.m. Mountain Time. He's based out of our Calgary office. And if you have any questions in the meantime, you can email us at help@employmentlawyer.ca or go to our website, employmentlawyer.ca. Thank you all, and I hope you have a great rest of your day.